B&S v. Leathley, 1979, Crim LR 314. The defendants, B and S, entered a freezer container that had been placed in a farmyard and stole goods from it. The container was resting on sleepers, weighed 3 tons and was 25 foot long by 7 by 7 feet. It had not been moved for over 2 years, had door and locks, and was connected to the mains electricity supply. The defendant was charged with burglary and subsequently appealed the decision to the Crown Court. Whether the trailer was at the building for the purposes of the Theft Act 1968. Under S.9(1)(a) of the 1968 Act, a person commits burglary only if they enter a building or part of a building as a trespasser. The term building is not defined except in S.9(4), which states that it may include an inhabited vehicle. There is nothing which states the building must be occupied. The container was at a building for the purposes of the 1968 Act. The court referred to Stevens v. Gorley, 1859, 141 ER 742, which predated the Act and in which it was held that a building was a structure of considerable size and intended to be permanent or at least to endure for a considerable time, per Biles J. at 112. The container fulfilled this criteria as it was likely to remain there for the foreseeable future. Therefore, it was a building for the purposes of the 1968 Act. Consequently, the defendant's appeal was rejected.